Okay, let's get the latest coming out of the Senzo Meyiwa murder trial. The testimony, or rather the cross-examination of Lieutenant Colonel Rapadu concluded today, and we've seen or heard from two new witnesses as well today who were attached to the SWAT unit at various points, one from 2019 to 2022 and one from 2013 to 2022. We speak to Elton Hart about what we heard today. Elton Hart, thank you very much for your time this afternoon. Perhaps let's start with what we heard from one of the defense advocates, Advocate Mshololo, when she was putting it to Advocate Rapadu, who has said that, well, he, according to him, accused number 2 never really indicated that he was assaulted. He never reported the assault. And Advocate Mshololo asking him, how could he, when he was a police officer self, but not just a police officer, but Ipoisa Elikhulu. Let's revisit that moment.
In fairness, Lieutenant Colonel, do you think the accused would have reported the assault by other police to someone who has introduced himself as Ipoisa Elikhulu?
It was in a format of a threat. I said it diplomatically that he understood. So there was no threat in that conversation.
Elton Hart, how useful was that interaction?
No, indeed, I think what Advocate Mshololo wanted to show, to say, listen here you have a police officer introducing himself to the accused person, and now this very same person needs to trust the very same people that he alleges has sort of half tortured him to actually entrust him with that information. And obviously this comes from the wider notion that some people don't trust the police at this point in time in our country because of certain elements that's happening. And I think she was trying to actually use that line of cross-examination to show that this person did not have the confidence at that point in time, especially after the colonel actually introduced himself as a member of the SAPS, to actually divulge further information. And it could have been that the accused person then would have had that perceived idea in his head that he might be tortured further if he sort of half pimps, if one used the South African local language for telling what happened to him to this police officer. He might give it to the other ones, and they might then come and further torture him and expose him to what they call tubing and those type of things that is not necessarily visible when you torture a person.
Colonel Rapadu was also asked about interpretation and the use of English instead of the use of the accused mother tongue. Let's revisit that moment by Advocate Mgomezu.
If you could see that he was not so good in English, how come you gave him the same statement that was recorded in English and expect him to read and understand the content of such a crucial statement which was recorded in English, after we have realized that he was not good in English? He may have said, yes, I know English, but as an officer of the court, not as an officer of the court, as the commissioned officer, you could pick up that, no, he was not good in English.
My Lord, I was just making sure that the contents of the statements is understood in the correct way. It was made freely and voluntarily.
I'm not talking about the issue of freely and voluntarily here. I'm referring to the issue of the correct interpretation and the issue whether the accused understood English.
The main thing is that I interpreted back to him. That is the crux of this matter, that I explained him in the language that he understood. For giving him to read, it was not a matter of, it was just to make sure that he can see that what I've written down, if he understands, he doesn't understand, but the main issue is that the interpretation was done to him.
Elton Hart, what is the standard, especially when you have so-called high-profile suspects? Should there be an interpreter present? What is the standard legally? What is required?
On his own version, this colonel, on his own version, he said he can see that this accused person is not versed in English. So merely on that, he was supposed to already say that, can we not get an interpreter in here? Because how do you explain stuff to a person in isiZulu and later on give him an English statement to say, read the statement and make sure it's correct, because that's what he said. That in itself means that it's like I'm coming to a Zulu guy and I give him an Afrikaans statement and say, read. I've now recorded everything because the form is in Afrikaans. Whatever I told you in isiZulu, I wrote it down in Afrikaans. You must read it. And I give that you have maybe little comprehension of Afrikaans. Is that fair? Is it in terms of the federal rights, in terms of his rights, in terms of Section 35? No, it's not. The mere fact is you can see this colonel is just trying to cover their bases to show the court that they actually followed procedure, well as it's now clear from the cross-examination. They did not follow procedures. They did not give a damn about the accused's rights if he does even understand what is happening and what he's doing to himself, the self-incrimination that's happening. For them, it was just a small little victory that they get a confession so they can close off this case, because there is political pressure, there is public pressure on them to actually get a conviction, be it the right person or the wrong person. But that's how I perceive what is transpiring. And most of these witnesses that has testified thus far, it seems like they're just now trying to cover their bases to show that they have met the master in terms of the Constitution, which I think they didn't.
And I do beg your pardon, that clip in fact was of Advocate Mshololo and not Advocate Mgomezulu. But let's revisit this moment when Lieutenant Colonel Rapadu was asked about whether the rights of the accused was explained to him. Let's revisit that moment.
Okay. When he was brought to you, you understood him to be an accused or a detained person? Because I heard yesterday in your examination that there is a difference between a detained and an accused person.
Yes.
Yes. Okay. So before you related to him as what type of?
He was a detainee.
If he was a detainee, then it means the right to be taken to court within 48 hours, sorry my lord, ought to have been explained. Or it was applicable to him, even if it was not explained, but it was applicable to him because he was a detained person. If it was not, you can say that there is no problem.
As far as I remember, it's an arrested person who must appear in court before the 48 person, not a detainee. That is the law.
And then, under the rights, constitutional rights, or amongst the constitutional rights that you explain to the accused in respect of the statement that you are about to take. You have introduced yourself, you have introduced the purpose. Ne? Did you inform the accused that he was not obliged to make a statement?
Correct.
Elton Hart, what's the difference between an arrested person and a detainee, and how useful will that interaction be for the court to come to a determination?
The thing is, like arrest and detained person, that's semantics for me. The state here wanted to now bring in that semantic, but the law is clear. If I'm a person that is arrested, I'm getting arrested now, then they can detain me for a period up to 48 hours. If they don't charge me in that 48 hours, they must release me. If they charge me, they must bring me to court. That's how that thing works. And they should not try and confuse the public that's actually also having an interest in this case. You get arrested, and once you get arrested, they need to make you aware of these rights, that you need to be brought before a court of law where you are being charged with a specific offense. And even him, as a police officer, as a commissioner of oaths, if you see that there is a gross violation of a person's right in terms of the Constitution, you are the first person, because you said to protect and serve who? The South African population. Why, when it came to his attention that this person was arrested on the 16th and then kept so long, I think around about 24, somewhere they give or take, did they not sort of half even find it necessary to say, let's get this person to appear on the case that he's arrested for, not on other cases, because he tried to cover his bases to say maybe he appeared on other cases that I don't know. But you knew that he was there for a case pertaining to the murder of Senator Meyiwa. Was he actually brought before court within 48 hours pertaining to that charge? And that's where we need to narrow it down and not try and play semantics with using of words at rest, detainee, those type of things, and try and confuse people.
Okay. Then let's go to the cross-examination of another state witness who took to the stand today, Nkosi Ngiphile Maphumulo, who's attached to the SWAT unit, because what the defense is arguing is that their clients were coerced. They did not make these so-called confession statements freely and fairly. It was under duress. In fact, they were tortured. We heard as much in terms of the version of events of accused number 1 yesterday, and this is what was put to the witness today in terms of whether he disputes whether the accused was assaulted in his presence.
Will you dispute the fact that the accused was assaulted in your presence?
We are Pika. I dispute that.
And if the accused had to have an opportunity to open a case against you for assault, your plea will be a plea of not guilty. Is that correct?
Yes.
Elton Hart, what is ultimately going to assist the court in determining whether this trial within the trial will eventually accept the so-called confession statements to actually be admitted as evidence, when you have one side saying, well, everything was according to the law, and one side saying it wasn't really?
No, for the state, they need to come, they need to bring everything to the table, and the role of a prosecutor is not to convict, is to make sure that the court has all the information. Now, at least the state was forthcoming with the people that transported these accused people. Now, if I was in the defense seat, I would also say, sir, on that particular day, what vehicle did you drive? And once we have established what vehicle he drove, I would ask for the AVL logs of that vehicle on that specific day to show all the venues and stops they made. And if it shows that where they said next to the steel factory where the accused alleged that he was assaulted, and it shows that the vehicle stopped there for 20 minutes or 30 minutes, it speaks to the version that the accused is putting to these witnesses. If it shows that the vehicle never stopped from where he was detained at a police station, he was taken directly to the place where the confession was taken and back to the police station it was held, then it dispels all this notion that torture could have happened in between the two venues where he was kept and where it was taken. So for the state to prove that these confessions must be handed in and admissible in evidence, they just need to bring that AVL log so that we can see. This is what the SWAT team was transporting this guy in, and there was no stops as alleged by the accused. And for the accused, they need to just do the other way around. But the state has access to this information, so they should be the ones that's actually bringing it to the court and say, here's the information, make a just and equitable decision.
Sure. In fact, Elton Hart, Mr. Maphumulo, did not record anything on the day. He did not even have his pocketbook with him, and the defense asked him how to prove that indeed you were even on duty that day. So we'll see how that pans out. Thank you very much, Elton Hart, for your time this afternoon.